Hello everyone, welcome to the channel of International Arbitration and Transnational Litigation in China. In today's presentation, I would like to talk about the regime governing choice of court agreement under Chinese law. More specifically, I will focus on a feature that really sets China apart, that is so-called actual connection requirement. In simple terms, this means that in purely domestic disputes, the court chosen in a choice of court agreement must have a real substantive nexus with dispute. By contrast, and this is important, in foreign-related or international contracts, no such requirement applies. In other words, the parties are free to choose any Chinese court. So, as you can see, China operates what we might call a dual-track framework. And in foreign-related or international contracts, under certain conditions, the parties may designate a foreign court. This dual approach is not just a technical quirk. It marks a significant divergence between Chinese law and the approach taken in most other major jurisdictions. And for that reason, understanding how it works is essential for anyone drafting or litigating cross-border contracts involving China. So let's step back for a moment. A choice of court agreement, sometimes we call it jurisdiction agreement or forum selection clause, allows contracting parties to agree in advance which court will have a dispute that might arise between them. Internationally, these agreements are recognized as expressions of party autonomy, promoting predictability, efficiency, and legal certainty. Now here's where things get interesting in China. Since the 2023 amendments to civil procedure law, a dual-track structure applies. For foreign-related disputes, for example, one party is a foreign national or foreign company, or the subject matter is located abroad, or the cause of action was accrued overseas. Article 277 makes it very clear. Parties may freely choose any Chinese court without any substantive link. That is a big step towards liberalization and in many ways aligns China more closely with international practice. But, this is a big but, for purely domestic disputes, Article 35 continues to impose the actual connection test. In other words, the chosen court must have some real nexus with the dispute. For instance, the domicile of a party, the place where the contract was formed and performed, or the location of the subject matter. If such a connection is missing, the jurisdiction clause may be simply deemed invalid. Let me now turn to another important provision, namely Article 280. This provision clarifies what happens when parties to foreign-related contracts choose a foreign court in their agreement. It tells two things. If parallel proceedings are brought both in a Chinese court and a foreign court of the same cause of action, same subject matter, same issue, the Chinese court may retain jurisdiction to accept the case if it has jurisdiction over the case. Second, if the parties have entered into an exclusive choice of a court agreement in favor of a foreign court, the Chinese court may decline jurisdiction, provided the case does not involve matters of exclusive jurisdiction and does not affect Chinese sovereignty, security, and public interests. So putting Article 277 and 280 together, we get a coherent picture that Article 277 emphasizes that parties in foreign disputes may freely choose any Chinese courts. Article 280 makes it clear that exclusive jurisdiction agreement in favor of foreign courts may be upheld subject to certain conditions. So it is quite clear that Chinese law recognizes the validity of choice of court agreement in favor of foreign courts in foreign-related contracts. So the legislative intent is not to prohibit such agreements, rather reserve Chinese courts' jurisdiction in matters of exclusive jurisdiction, sovereignty, national security, and public interests, while allow party autonomy to prevail in ordinary cross-border transactions. So what does this mean in practice? Let me highlight three key takeaways. First, always ask whether the contract is foreign-related. If it is, the parties enjoy considerable freedom in choosing a Chinese court or even foreign court. Second, if we are drafting a forum selection clause, in a purely domestic contract, be careful. The designated court must satisfy the actual connection test. Otherwise, your clause may be simply struck down at the outset. Third, if the situation is where certainty of forum is a high priority in domestic transactions, it may be worth considering arbitration. Unlike court jurisdiction agreements, arbitration clauses are not subject to the same territorial nexus test. So, to sum up, the Chinese approach to jurisdiction agreements is marked by this dual-track system: liberal for foreign disputes, stricter to purely domestic disputes. And Article 280 adds another layer of nuance when foreign courts are involved. For lawyers and businesses, keeping these distinctions in mind is crucial. And that's the end of this presentation. Thanks for your watching.